I didn't take much. Client correspondence, delivery confirmations, contract amendments, review notes. Everything already existed in shared systems. I just made local copies. Then I logged off, packed my desk, left my access badge on the CFO's assistant's desk. No one stopped me. The office felt different as I walked out. Quieter. People looked away. I'd been terminated before the end of my contract period. 6 months early. That meant something. I just didn't know what yet. I spent the weekend reviewing everything. My contract had a termination clause, standard language. Either party could end the engagement with 30 days' notice, or immediately, for cause. Cause was defined: breach of confidentiality, gross negligence, failure to perform contracted duties. The letter cited performance, but performance wasn't cause. It was subjective. It required documentation, progressive warnings, a paper trail. They had none of that, which meant they owed me 30 days' pay, plus contract completion terms. I calculated the amount. Then I called my consulting firm Monday morning. "I need to understand the termination process," I said. My director sounded uncomfortable. "The client has discretion. If they're not satisfied..." "Was I terminated for cause?" Silence. "The letter says performance issues," he said carefully. "That's not cause under my contract." "Veronica, I understand you're upset, but..." "I'm not upset. I'm clarifying terms." He paused. "I'll check with legal." I thanked him, hung up, then awaited. 3 days passed. No call, no email, no clarification. I checked my bank account. My final paycheck had been processed. Regular amount, no severance, no notice period. I sent one email to my director. "Following up on our conversation, please confirm, was my termination for cause or without cause? This determines notice period obligations under Section 7.3 of my contract." Professional, simple, direct. He responded 6 hours later. "We're reviewing with the client. We'll update soon." I read it twice. The client. Not legal, not HR. The bank was making decisions about my employment terms, not my actual employer. That was the second unusual thing. I opened a new document, started a timeline. Date of last performance review, date of termination, date of final payment. Then I added another column: contract terms, notice requirements, cause definitions. The gaps were obvious. A week went by. I applied for other contracts, updated my resume, stayed professional. But I kept checking email. Nothing from my consulting firm, nothing from the bank. It was as if I'd never existed. I thought about the CFO, Michael Strauss, mid-50s, 20 years at the bank. He'd barely spoken to me in 4 years. I reported to the head of risk. She reported to him. I'd seen him in meetings, quarterly reviews, board presentations. He signed off on my renewals every year. Standard process. Now he'd signed my termination. Why? I pulled up old emails, searched for his name. Most were procedural, approval chains, budget confirmations. Then I found one from 8 months ago. Subject: Regulatory Inquiry, External Consultants. The Australian Prudential Regulation Authority had flagged the bank's use of long-term contractors in compliance roles. They wanted documentation, justification, proof that consultants weren't performing roles that should be permanent positions. The bank had responded. I'd helped draft parts of it. We'd outlined my deliverables, scope limitations, contract terms. It had satisfied the regulator. But now I wondered, had the bank decided I was a liability, someone who knew too much, stayed too long? I couldn't prove it, but the timing fit. 2 weeks after termination, my director called. "We've reviewed your contract," he said. "You're correct. The termination wasn't for cause. You're owed notice pay." 30 days? Yes. When will it be processed? The client is handling the payment directly. I stopped. Why? It's complicated. They want to settle this internally. I don't work for them. I work for you. Technically, yes, but the payment arrangement was structured through them. It's in the contract addendum. I pulled up my files, found the addendum. He was right. Payment processing went through the bank's accounts payable. My consulting firm invoiced them. They paid me. It was a common setup for embedded consultants, but it meant the bank controlled the money. When? I asked again. They said within 30 days. That's the amount they owe, not the timeline. I'll follow up. He or I sat there, staring at the addendum. The consulting. Days turned into weeks. I sent polite follow-ups, professional, measured, checking on the status of my notice pay. Following up per our previous conversation. Requesting confirmation of payment timeline. No response from the bank. My director sent vague updates. Still in process. Finance is reviewing. Should be soon. I stopped responding. Instead, I went back to my files, the work I'd done for 4 years. Compliance audits, risk assessments, regulatory filings. I knew the bank's structure, their exposure, their vulnerabilities, not because I was looking for them, because that was my job. I'd documented non-compliance issues, flagged risks, recommended corrections. Most had been fixed, some hadn't. I opened my records, cross-referenced dates. 3 issues remained open, minor but persistent. One involved related party transactions that weren't fully disclosed in quarterly reports. Another involved credit risk modelling that didn't quite meet APRA standards. The third was about consultant classification. My classification. That one was interesting. APRA guidelines were clear. Contractors performing ongoing control functions had to be properly supervised. Their work had to be reviewed by permanent staff. They couldn't be the sole expert in a critical area. I'd been the only compliance consultant embedded full-time. I'd worked independently. My reports went to the head of risk, but she didn't have compliance expertise. She relied on my assessments. For 4 years. That was a problem. Not for me, for the bank. If APRA audited them again, they'd have questions. Why was a contractor operating independently in a control function? Where was the oversight? Why hadn't this been corrected after the last inquiry? I didn't plan to report it, but I didn't have to. APRA conducted random audits. They reviewed regulatory filings. They asked questions. And I'd helped write the bank's last response. I knew exactly what they'd said. I knew exactly what was still true. 5 weeks after termination, I received an email. Not from my director, from the bank's legal department. Subject: settlement offer. I opened it. They were offering my notice pay. 30 days, plus an additional sum, in exchange for a release, a non-disclosure agreement, and a non-disparagement clause. The additional sum was modest, 3 months' pay. The NDA was comprehensive. I couldn't discuss my work, the termination, the bank's operations, anything. The non-disparagement clause prevented me from making negative statements about the bank, ever. I read it 3 times. They were scared. Not of a lawsuit. The amount was too small for that. They were scared of what I knew. I didn't respond immediately. I reviewed my contract again, my termination letter, my documentation. Then I reviewed something else. APRA's public guidance on whistleblower protections. Consultants who reported regulatory violations were protected. NDAs couldn't prevent disclosure to regulators. I wasn't planning to report anything, but the bank didn't know that. I drafted a response. Thank you for the settlement offer. I'm reviewing it with independent counsel. I have questions about Section 4.2 regarding scope of confidentiality obligations, specifically whether this precludes communication with regulatory authorities if contacted. Please clarify. Professional, calm, procedural. I sent it. The response came within 2 hours, from the CFO's office directly. They wanted to schedule a call. I declined. Please provide written clarification first. Another email arrived that afternoon. The NDA had been revised. New language. Regulatory communications were explicitly excluded. The settlement amount had increased. 6 months' pay plus notice period. I calculated the total. It was significant, more than I'd expected to fight for. But I didn't accept. I sent one more question. Does this settlement require mutual non-disparagement, or only from my side? Silence. For 3 days. Then a new email. Different attorney, senior partner at an external firm. The tone had changed. Ms. Hale, we'd like to resolve this matter efficiently and fairly. The revised settlement terms include mutual non-disparagement and a standard confidentiality framework. We believe this is reasonable for both parties. Mutual non-disparagement meant they couldn't speak about me either. That was new. I replied, "Thank you. I'll review and respond within 1 week." Then I waited again. During that week, I did nothing. I didn't contact APRA, didn't threaten, didn't posture. I just existed. I went to the gym, met friends for coffee, interviewed for other roles. I checked email twice a day. On day 4, another message arrived, from my former consulting firm. Veronica, we've been contacted by the bank regarding your settlement discussions. We want to ensure you're receiving proper support. Please let us know if you need anything. I read between the lines. The bank had reached out to them, asked questions, maybe applied pressure. My consulting firm was protecting itself. I responded simply, "Thank you. I'm handling this directly with the bank's counsel. I'll let you know when it's resolved." Professional distance. On day 6, the attorney called. I didn't answer. He left a voicemail. "Miss Hale, I'd appreciate the opportunity to discuss the settlement terms. Please call at your convenience." I didn't call back. On day 7, I sent my response. I've reviewed the terms. I'm willing to proceed with the following modifications. Settlement amount: 9 months' pay plus notice period. Confidentiality excludes all regulatory communications and responses to official inquiries. Mutual non-disparagement includes the bank's executives and board members individually. Reference language: the bank will confirm my employment dates and role only, with no performance characterization. I kept my tone neutral, not demanding, just stating terms. Then I added one line. These terms reflect the complexity of my role and the sensitive nature of the work I performed. I believe they're fair. I sent it. 2 days passed, then a response. We can agree to 8 months' pay plus notice period. The other terms are acceptable. 8 months was more than I'd expected to get, but I didn't accept immediately. I waited another day. Then I sent one word. Agreed. The settlement documents arrived within a week, 15 pages, dense legal language. I read every word. The payment structure was clear, lump sum, processed within 10 business days of signing. The confidentiality terms matched what we'd discussed, standard language. Regulatory carve-out explicit. The mutual non-disparagement clause listed names: the CFO, the CEO, 3 board members. That was unusual, specific, protective. The reference language was restrictive, dates and title only, no elaboration. I reviewed it twice, then I signed. I scanned it, sent it back. Then I waited for the money. It arrived 9 days later, the full amount, exactly as specified. I transferred it to savings, paid off my car, put the rest aside. Then I closed my files, all the documentation, the emails, the contract records. I backed them up, encrypted the drive, put it in a drawer. I didn't need them anymore. But I kept them anyway. No, wait. I archived them properly. Then I moved on. 3 months later, I started a new contract, different firm, different client, different city. I saw a news article about my old bank. A PRA had conducted a routine audit, found some minor compliance gaps, issued recommendations. The bank had responded appropriately, hired a new head of compliance, permanent position, proper oversight structure. No fines, no enforcement action, just corrections. I read the article once, then closed it. 6 months after that, I got an email from the head of risk at the bank, the woman I'd reported to. Subject: reference request. She was job hunting, needed a reference. I stared at it for a long time. Then I replied, I can confirm your title and employment dates. Best of luck. Professional, appropriate, limited. She responded, Thank you, I understand. I think she did. I never spoke about what happened, not to friends, not to colleagues, not in interviews. When people asked why I'd left, I said the contract ended, which was true. When they asked about the bank, I said it was a good experience, which was also true. I'd learned a lot. The NDA made it easy. I didn't have to explain. I just had to be professional, and I was good at that. Years later, I saw the CFO's name in a business publication. He'd retired, moved to a board position at another bank. The article called him a steady hand, someone who'd navigated regulatory challenges with integrity. I read it without feeling anything. Maybe it was true. Maybe it wasn't. It didn't matter anymore. He'd made a decision. I'd responded professionally. The system had worked. Not perfectly, but adequately. I still do compliance work. Different clients, different projects. I'm careful about contract terms now. I read every clause. I clarify expectations up front. I document everything. Not because I'm paranoid, because I'm professional, and because I know what happens when assumptions replace clarity. Sometimes I think about that termination letter, the mismatch between what they claimed and what the records showed. It wasn't personal. I know that now. It was business, risk management, liability reduction. They saw a problem. I was part of it, so they removed me. The mistake was in how they did it. The false performance claim, the contract violation, the stalling. They created exposure while trying to eliminate it. I didn't exploit that. I just pointed it out, quietly. And they paid to make it go away. I never regretted the settlement. Some people asked if I should have fought harder, gone public, made noise. But that wasn't the goal. The goal was fair compensation for improper termination. I got it. Everything else was just leverage. The bank still operates. They're profitable, stable, well regarded. I hold no ill will. They made a mistake. They corrected it. They paid for it. That's how it's supposed to work. I learned something from that experience. Power isn't about confrontation. It's about knowing what you have, what the other side needs, and when to stay quiet. I never threatened the bank. I never had to. They knew what I knew, and they knew I knew they knew. That was enough. The settlement agreement is still in a file somewhere, encrypted, backed up, accessible if needed. I haven't looked at it in years. I don't need to. The terms were clear, the payment was made, the matter was closed. I think about Veronica sometimes, the person I was when I walked out of that bank. Angry, confused, uncertain. I'm not her anymore. I'm someone who knows her value, someone who documents her work, someone who reads every contract, someone who waits. The best revenge isn't dramatic. It's not public exposure or courtroom battles. It's getting exactly what you're owed. Nothing more, nothing less. And moving on. I never went back to Perth. New opportunities came, different cities, different challenges. I took them. The bank became a line on my resume. 4 years, compliance consulting, embedded role. That's all it needed to be. People ask sometimes if I miss it, the stability, the long-term client relationship, the deep knowledge of one organisation. I tell them no, because I don't. I prefer variety now, short contracts, clear deliverables, clean exits, less attachment, less risk. The CFO never contacted me. Neither did anyone else from the bank. The settlement closed it completely. No loose ends, no lingering questions, just a transaction. Completed, filed away. I saw my old consulting firm's name recently. They're still in business, still placing contractors, still doing the same work. I wondered if they learned anything, if they protect their consultants better now, if they push back when clients overstep. Probably not. It's not profitable to fight for contractors, easier to replace them. I understand that. I don't blame them, but I don't work for them anymore either. The work I do now is different. Shorter contracts, higher rates, clearer boundaries. I stay professional. I deliver quality. I leave when it's time. No one questions it. Because that's what consultants do. We come in, we solve problems, we move on. The bank wanted me gone, so I left. They just paid more for it than they'd planned. I keep my skills current. Regulatory changes, compliance frameworks, risk methodologies. The work evolves. I evolve with it. I'm good at what I do. Better than I was 5 years ago. Better than I was the day they terminated me. Sometimes I wonder what would have happened if I'd fought differently, if I'd hired a lawyer immediately, if I'd filed complaints, if I'd made noise. Maybe I'd have gotten more money. Maybe I'd have gotten nothing. Maybe I'd still be fighting. I'm glad I didn't find out. The settlement taught me something valuable. Silence is a strategy. Patience is a weapon. Documentation is power. And knowing when to walk away is worth more than winning. I never became the bank's owner. The title was hyperbole. But for a few weeks I had something better. I had leverage they couldn't ignore. Information they needed contained, and the professionalism to use it correctly. That was enough. The files are still encrypted, the settlement is still valid, the matter is still closed, and I'm still here, working, thriving, moving forward. They treated me like nothing, so I showed them what nothing costs.